Try this one.
Mr. Mendez, are you ready? We're ready to hear you.
So I was give me the extra 15. Huh? Got you?
Oh, I see. Okay, got it. Who did help the motion?
You can do it from the back. You want some? Yeah.
Are you ready? Are you hearing us?
Sorry, yes, I'm hearing you. I had the volume down. I apologize. I'm ready.
Yes, please go ahead.
I'm sorry, Your Honors, I couldn't see that you all had entered the court. I apologize. Your Honor, the history of this case is, of course, well known to everyone. It began when the returning officer, Mr. Clement Mingo, conjured into being 20,000 extra votes for the APNU. This led to the order, ultimately to the order for recount that the commission had made, and about which much has been said in these proceedings, that is to say, the order. And as a consequence of that recount, it has been established, and I don't think anybody is disputing, that Mr. Mingo had in fact invented these 20,000 extra votes. Now, I've listened with some bemusement to the passion with which the Honorable Attorney General was calling upon the court to ensure that that there was a fair election. And he was, of course, very concerned and hot under the collar about all of these allegations, and they're nothing more than allegations, of irregularities that were discovered during the course of the recount. But I was really surprised that he expressed absolutely no concern or even worry about the fact that what the applicants are in the end saying in this case is that we must go back to Mr. Mingo's count. I haven't heard him express any horror at all, anything approaching horror, that they are asking, in effect, that an election be determined on the basis of fraudulent votes, votes that have been determined by the recount to be fraudulent. But it's against that backdrop that it is easy to appreciate that the application that has been made here is a cynical one. It is indeed, it is a hopeless application for all of the reasons that we have indicated. And because I have a very short period of time in which to make this submission, I will attempt to be as quick as possible. I have seen an email from a learned friend, Mr. Cashier, who has indicated that he's prepared to cede to me 15 minutes of his submission because he hadn't seen the applicant's reply. I don't know if the court would be minded to accede to his request, but I'll see how it goes. Your Honor, the first problem with the applicant's application is that there are no rules made by Parliament. There are no provisions made by Parliament governing the conduct of the application that the applicant is making. And I am, of course, very mindful of the John Doe principle and of all the other cases that follow John Doe, and in fact we refer to it in our submissions. But John Doe does not deal with the type of case that the Court of Appeal of Trinidad and Tobago dealt with in Peters and Chaitan, which is that case in which the making of rules is interpreted to be a precondition to the exercise of jurisdiction. We say that our case falls within that category of case. That is to say, that the making of provisions governing who is to bring an application and the manner and the conditions under which the application is to be brought is a precondition to the court assuming jurisdiction. And we say that this case is different to the John Doe type of case because Article 155(5), which vests in Parliament the power to make provisions, says, subject to the provisions of this Constitution, Parliament may make provision for giving effect to the provisions of this title. In other words, until those provisions are made, effect has not yet been given to the jurisdiction of the court, which is expressed in the immediately preceding subparagraph 4. None of the cases that followed John Doe deal with a similar provision that says that the provisions are needed to give effect to the jurisdiction of the court. None of them say that. John Doe does not say that. In all of those cases, the jurisdiction is given without condition, and then there's a provision that says that rules are to be made, and the courts have interpreted that to mean the jurisdiction is complete, and therefore the court can exercise that jurisdiction following any existing appropriate procedure, and is not necessary for the procedures or the regulations to be made in order that the court may exercise its jurisdiction. This is an entirely different case. I will not dwell on it anymore, except to point out that in the absence of rules, in the absence of provisions governing, for example, the time within which an application under Section 177(4) can be made, it could very well be that this election is declared, the president is then elected, and 3 years from now, somebody seeks to invoke the jurisdiction of the court under Section 177(4), and nobody will be able to say that you're out of time, because there are no provisions governing the time within which the application is to be made, as there are time limitations for bringing election petitions in relation to the jurisdiction of the High Court under Article 163. So the making of provisions is not a trifling thing in a case such as this. Clearly, Parliament intended that those provisions be made so that we can know exactly what the rules are, what the conditions are, who can bring the application, and so on, before effect is given to the jurisdiction of the court. And therefore, this is an entirely different case than the John Doe type case. The second point is that this is a jurisdiction which, on the ordinary word of the word used in Section 177(4), can only be exercised once there is an election of a president. Can't be exercised before the president is elected. It says that. This is the words are, the Court of Appeal shall have exclusive jurisdiction to hear and determine what? Any question as to the validity of an election of a president. So that is what you have jurisdiction to hear and determine. A question as to the validity of an election. If an election has not yet occurred, then your jurisdiction does not yet arise. That's a simple point that is made by the Commission, that is made by this respondent, and I believe by the other respondents as well. What the applicant has to do is to await the declaration of the election of the president before seeking to invoke the jurisdiction of the court under Article 177(4). And that election, the election of the president, only occurs after there's a declaration from the chairman of the commission. And as my learned friend Mr. Jeremy had pointed out earlier in his submission, Section 177(2)(b) speaks about the chairman acting on the basis of the advice of the chief elections officer. That has not yet occurred, so we don't yet have an election. As a matter of fact, maybe there won't be an election at all, or unlikely, but maybe there won't be an election of Dr. Ali. We have to wait and see whether there is such an election before the jurisdiction of this court can be invoked on the plain words used in Article 177(4). So on either of these two bases, Your Honors, this application ought not to be entertained at all, in which case we don't need to go on to consider all of the other very interesting questions that my learned friends have raised in relation to the conduct of this particular election. But of course, questions have been asked about the competing jurisdictions of the Court of Appeal and the High Court, and I will proceed to address them. Of course, I rely on our written submissions, and I will attempt to be as brief as possible in addressing that question. Now, Your Honor, it is important to bear in mind what it is that the applicant and the Honorable Attorney General are asking this court to find. What are the determinations that they are asking you to make? Well, it's very interesting that I have not heard it fall from anyone's lips to say that you must determine that the election of Dr. Ali or anyone else is invalid. They haven't asked you to make that finding. And that in itself is a clue that we are not yet in a Article 177.4 situation. All they have been speaking about at great length is, in the first place, all these irregularities and discrepancies, and we're taking the time to list those, the categories of irregularities in our reply. We've seen, they've said a number of things went wrong. The genesis of their complaint. Then they say, well, on the basis of those complaints, the Chief Election Officer, in producing his report on the recount, apart from reporting on and he uses the word valid, apart from reporting on the valid votes, he uses those words in his report, and reporting that the PPP won the election by 15,000 odd votes. Apart from making that report, he then goes on to say that the election was not fair, it was not credible because of all of those irregularities that he somehow makes a determination on. He makes that determination. Why he does so? Because nobody asked him to. And indeed, there's nothing in the order for the recount that requires him to do that. There's nothing in the representation of the People's Act that requires him to make that any such determination. But he does. He makes the determination. Who he has heard in making that determination, we don't know. Certainly didn't hear from us. We made no representations to him, but he made that determination. And my learned friends rely on that. They say, here is the Chief Election Officer saying that there's a problem with the election. And then they go on to say, well, when you look at the order that for the recount that is made by the Commission is required to, and this is their interpretation, the Commission is required to make a determination as to the credibility of the election. They must do that before they go on to declare the winners. That is what they are saying. Now, Your Honors, I am quite happy to get involved in a debate on what exactly the order requires and what exactly the duties and responsibilities of the Commission may be. Quite happy to engage in that debate. But the point is that that is not a debate. Those are not questions that are reserved for the jurisdiction of this court under Article 177.4. So as interesting as the question might be, what must the Commission do under the order? That is not a question for this court to answer under Article 177.4. It may be a question for you to answer on an appeal from the High Court in an election petition, but it is not a question for you to answer on this application. Why is that so? Because we must look, there are competing jurisdictions. There's a jurisdiction of the Court of Appeal under Article 177.4, and there is the jurisdiction of the High Court under Article 163, 1B, and it is very important to look at the terms of that provision. What it says is, subject to the provisions of this article, this is 163.1, the High Court shall have exclusive jurisdiction to determine in any question, A, regarding the qualification of any person to be elected as a member of the National Assembly. Now, if we pause for one moment, the only qualification question that the High Court can determine under its exclusive jurisdiction is the qualification of a person to be a member of the National Assembly. We can immediately cross-reference that to 177.4, where it is the Court of Appeal that has the exclusive jurisdiction to determine the validity of the election of the President, insofar as that depends upon the qualifications of the President. So there's a clear demarcation there. The Court of Appeal determines qualifications for the President. The High Court determines the qualification for members of National Assembly. So there's a clear division there, and there's no problem as far as that is concerned. But when you go on to 163(1)(b), it then says, whether generally or in any particular place an election has been lawfully conducted or the result thereof has been or may have been affected by an unlawful act or omission. Now I understand the applicant and the Honorable Attorney General to be saying that there is a glaring omission in this case. The omission is that GECOM did not determine and is refusing to determine the credibility of the election based upon all of these irregularities. But that is the quintessential type of question. All of these irregularities that they're referring to, which they say affects the election, and the omission made by GECOM, which they say that GECOM was required to make that determination. All of those things are things that fall squarely within the exclusive jurisdiction of the High Court, because those questions that they wish to raise impacts upon the election of the members of the National Assembly. They are saying that their votes are invalid, and if you discount the votes, the APNU wins. That is what I believe the Chief Election Officer is saying. That's what I believe is at the heart of the case that the Honorable Attorney General is making. It would put his party back into power if all of these things are discounted. But that falls within the exclusive jurisdiction of the High Court to determine. Now, it cannot possibly be the case, as my learned friend Mr. Jeremy is trying to do, that you can separate in this instance the election of the president from the election of the members of the National Assembly, because the Constitution provides that a vote for a list is deemed to be a vote for the president. So if you are challenging the vote for the list as being invalid, you are in effect challenging the validity of the vote for the president. Both of those, therefore, fall under the exclusive jurisdiction of the High Court. Put simply, if you bring an election petition and you challenge the election on the basis that there have been invalid votes for all of the reasons that Mr. Harman has given in his letters, or the GECOM says that or the point is that the GECOM failed to determine whether they are credible and therefore that affects the validity of the election, then the validity of the entire election is put in question. And therefore the validity of the election of the president must also be put in question, because his election depends upon the list on which his name appears winning the election. So it is plain and obvious, and I don't think anybody has suggested that the questions which the applicant and the Honorable Attorney General have raised in this case fall squarely within the exclusive jurisdiction of the High Court. And I believe that that is the point as well that my learned friend representing the chairman of GECOM has made. So the question is, if it falls within the exclusive jurisdiction of the High Court, under what circumstances can this court, in its original jurisdiction under Article 177(4), exercise jurisdiction to determine those very questions? Because a problem immediately arises. If two courts have jurisdiction to determine the same question, then there's a possibility that you might have different conclusions. As a matter of fact, if you can invalidate the election of the president under Article 177(4), that's all you can do. You can't invalidate the election of the members to the National Assembly. So you might have a situation where you determine that the president's election is invalid, but the High Court determines that the election of the members of the National Assembly is valid. So I don't know who the president will be in those circumstances, but you will have a party in power in the National Assembly and no president. How is that possible? It means, therefore, Your Honor, that you have to be very careful about the jurisdiction that you assume under Article 177(4) when plainly the questions that are being raised in this case fall squarely within the jurisdiction of the High Court under Article 163(1)(b). So we must therefore look very carefully at the jurisdiction of the court under 177(4), and we have to look back at the words that are used. And I'm reading from the section, if I may. The Court of Appeal shall have exclusive jurisdiction to hear and determine any question And this is it, any question as to the validity of the election of a president. So that is what you can determine. No other question. The question that you can determine is as to the validity of an election of a president. But it goes further, limits the jurisdiction even further. Insofar as that question depends upon the qualification of any person, that's one, for election, or two, the interpretation of this Constitution. So if the question as to the validity of the election of president does not depend upon the interpretation of the Constitution, you do not have jurisdiction. It is as plain and simple as that. So we have to ask the question, when the applicant and the Honorable Attorney General say that the validity of the election is in question, what does that depend upon? What finding does that depend upon? And you have heard what my learned friend Mr. Jeremy and the Honorable Attorney General has said all morning. You have read their submissions, and all that they have spoken about are the irregularities, the chief election officer's ultra vires determination on credibility, and then the Commission's failure to make a determination as credibility. That is all that they have spoken about. The Honorable Attorney General is very revealing in his submissions because he spent a lot of time going through the order and interpreting it. So the validity of the election, according to them, depends upon the correct interpretation of the order and what the obligations of the Commission are. It does not depend upon the interpretation of the Constitution. That is what they... And again, if you start from the proposition that those questions that they are raising already fall within the exclusive jurisdiction of the High Court, it seems impossible to say at the same time that it falls within the exclusive jurisdiction of the Court of Appeal. Now, Your Honor, the President of the Court had asked a very important question, directed my learned friends attention to Article 133 of the Constitution, and my learned friend Mr. Jeremy, at the urging of his juniors, indicated that that was simply not relevant. But of course it is relevant, because that is the section that says that this court has the power on an appeal to determine questions of the interpretation of the Constitution on an appeal from the decision of the High Court. So the Constitution is telling you that the Court of Appeal does determine questions of interpretation of the Constitution when they come through the High Court. So it means that this jurisdiction that you're exercising in 177.4 is even narrower than you would have thought if you didn't look at 133. And we know that from previous rulings of this court, from the High Court of Guyana, and a number of different cases that have been referred to this court in the Ulita Moore case, that on an election petition, the High Court can also consider constitutional questions. They can invalidate an election, in other words, on the basis of a violation of a provision of the Constitution. So it is quite possible, and indeed it happens quite frequently, that a question concerning the interpretation of the Constitution comes to the Court of Appeal by way of an appeal from the High Court in an election petition. So it must mean that the area of jurisdiction that is constituted by the words invalidity depending upon the interpretation of the Constitution must be very narrow. You cannot contrive an interpretation of the Constitution. You cannot come to the court and point out, as my learned friends have done, and they've spent a lot of time on it, speaking about the proper interpretation of GECOM's order, and then say, well, I'm going to tack it on to this provision. How am I tacking it on? I am going to ask you to interpret Article 177.2b by inserting words. Where the words more votes cast, you have to insert it in there, more credible and valid votes. You have to insert those words in. And that is how they are trying to link your jurisdiction on 177.4 with the real complaint in this case, when the real complaint in this case falls within the exclusive jurisdiction of the High Court. Now, Your Honor, yes, Your Honor.
finish that point, then I will ask my question. You finish off.
Certainly. Well, I think I lost my train of thought, so maybe you can ask the question and it might come back.
Well, I understand your submission quite clearly on the jurisdiction point, Article 177, for that special jurisdiction that you have discussed. But you mentioned in the history of the case how we got to this point, and you mentioned that a recount was held as a result of discrepancies which you described. So is that really not an issue? That's it. That's the problem, because if, as you recognize in history, the irregularities caused the recount. The irregularities led to the recount. So that at this stage, before declaration, you had appreciation of that would be the first set of figures, and you go to the recount. And the first set of figures were appreciated because of the irregularities. Let's call them that, or you say fraud, but let's call them irregularities and or fraud. You say, but then now we come to the recount, and one side says fraud, and the other side says irregularity. But really, the issue is, so what is the status of the order, or the fixed day of 2020 and the amendment? Because, and to that is the problem in the case if you have this court. Well, yes, the jurisdiction is the first thing, but as we are on it, and we mention it as part of the history, I think it's relevant, let's put it like that, for the time being. How come those irregularities before that led to the recount had an impact at this stage, but then you say that the irregularities that now emerge ought not to have an impact at this stage, but should really go to the election petition. Remember, all those arguments were raised before, that those should go to an election petition and the court exercise the jurisdiction. I'm not saying we're going as far as that in this case, but you mentioned it in the history, and to my mind, that is an area of doubt in the whole case. We ask ourselves, well, why is it that those irregularities that were initiated long before a declaration, but now irregularities come up, and we say, we are proceeding, that those should be by way of the election petition. So what then is the status of this order? That is the question. This is, of course, separate from all this jurisdiction. The court may agree with you that it ought not even to go there, but I believe that it has come up, it keeps coming up, and you mentioned it as part of it. So what is the status of that order?
And Your Honor, I am going to answer you directly. But if I may say, first of all, that inquiry as to the status of those regularities is an inquiry that ought to be made, and a judicial determination on it ought to be made at some point in time. The question that we are asking is whether it can be made now in an application under Article 177(4). That is the primary question. The question is whether this court has the jurisdiction.
Yes, I understand that.
Well, that's my first answer. That's my first answer to the question. But my second answer to the question is, when you say what is to happen to those irregularities, my answer to that question is that those irregularities must be taken up and dealt with in an election petition. That is the second answer. It is not that the law says that you must ignore those irregularities. What it says is that you must determine those irregularities in an election petition. And again, there are a number of authorities that say that that is where you go. If you have a complaint about an election, irregularities in an election, and the ones that raised by Mr. Harman are the classic type of irregularities that you find from time to time, unfortunately, in every election in the entire world. I don't think that there's any election that we have heard about in which irregularities of that sort are not raised. The consistent answer from the court, including from the CCJ, is that those irregularities must be dealt with by an election petition. My third answer to what you have said is that the GECOM has considered the alleged irregularities raised by Mr. Harman, and you see a press release that has been put before you in which they have said, and I will quote from the press release. I just had a copy of it in front of me here. Yes. In the press release, it is exhibited as document F to Esyln David's affidavit on the 18th of June. They said, after considerable deliberations at the Commission on the report submitted by the Chief Elections Officer on the national recount of votes cast on 2nd May, the chairperson, Claudette Singh, has requested the CBO to prepare a report to ascertain the results. Then she said, in her decision to the Commission of 16th June, Justice Singh asserted that the Commission does not have the powers of a court of law to examine and re-examine witnesses or to produce official documents to determine the truth of the allegations contained therein. So what she is saying is that I've listened to all of these things, I've seen the complaints and so on, but we can't determine the truth of it. Simply, let's give a simple examination, a simple example. One of the allegations that has exercised Mr. Harman is that there were people who were voting, who were recorded as turning up to vote, but they're out of the country. That's what he said. Now, how are you going to determine that as a matter of fact? Unless you do an inquiry in relation to each voter who it is alleged voted but was out of the country. In other words, somebody voted for them. You're going to have to bring that person in and ask them, were you in the country at the time? And you have to make a determination in relation to each vote. So it's not that GECOM ignored it. What GECOM did was to say, we don't have the capacity, and I think that they were obviously right in that, we don't have the capacity to conduct the type of inquiry, examining, re-examining, cross-examining witnesses, etc., in order to make a determination as to whether that person was impersonated. I'm just giving that as one example. I can go through the plethora of examples.
I don't want to take up so much more of your time.
So that's much obliged.
That is a query in my mind, and I speak to myself, that there seems to be the need to make a distinction between what was alleged to be irregularities, or what were alleged to be irregularities earlier in the process, and what are alleged to be irregularities now. So I'm saying maybe if you can distinguish the status of the two complaints.
Yes, certainly.
Go on, because some
yes,
of course this court having any jurisdiction at all, but
absolutely, but
it is part of the whole matrix of the case.
The distinction is this. In the litigation that was in the High Court and eventually got to the Court of Appeal, there was evidence that was put before the court that was never disputed. I repeat, there was evidence that was put before the court, never disputed by anybody, that the statements of the poll, copies of which the PPP had in its possession, when you add up those statements of the poll in their possession, Mr. Mingo was giving APNU 20,000 more votes than they actually got. That was the evidence before the court, which was never in dispute. Nobody went on affidavit and said, you're wrong, we have statements of the poll, and we came to a different conclusion. That was never in dispute. And that has now been confirmed by the recount. The recount has shown that the PPP was always correct when they said that the statements of the poll show that Mr. Mingo conjured into existence 20,000 more votes for the APNU and therefore created a fraud. So that is what caused the disquiet in Guyana. I'm not suggesting that any irregularity in an election should be ignored, but I am saying that that irregularity, if you want to be generous to call it simply an irregularity and not a fraud, that is certainly something that does not occur with any frequency at all. As a matter of fact, it is unheard of in the Commonwealth that you have a situation where 20,000 votes are invented. That does not happen. And it's not
so later down the line, so how do we distinguish what are alleged later down the line? So just for the education of the court, what should be the view on the status of those allegations?
The difference again is that in relation to Mr. Mingo's fraud, there was an international outcry. All observers were saying the same thing. In this particular instance, on the other hand, the observers, while they are saying that there were irregularities, they are concluding that the election was nevertheless fair, focusing on the fact that you have to give effect to the wishes of the electorate. And it has been confirmed by Mr. Mingo in his report when he says that there were valid votes counted. He says that the valid votes that were counted on the recount, in other words, they went back to each ballot and they counted it. It shows that the PPP is in the lead. That is the big difference. Now, Your Honor, I am not saying that one should ignore Mr. Harman's complaints. I'm not saying that they should be ignored. The question that has to be answered is, in what forum is Mr. Harman's complaints to be examined and analyzed and determined? And there is a forum that exists under the Constitution, that is before the High Court. Now, I'm also happy to engage in a debate as to whether the GECOM has the power itself to make that determination, even though the High Court is given the exclusive jurisdiction to determine it. I'm happy to do that as well. But that is not a question for this court under Article 177.4. And I'm happy to do it.
I want to show you I understand your point about the jurisdiction on the 177.4.
Well, okay, so
raised it as part of the history of the case. And
yeah.
it's picking up on that I asked my question, but I'm not certainly in any doubt as to your submissions regarding the court's narrow jurisdiction on the 177.4.
If I may
you raise it because it is an issue that keeps coming up all the time in the media and so on that we've all been reading. So I asked if it was counting the affidavits and the core of the applicants, the part of the applicants' needs, then in that case, and go any further at this point. But to that extent, I asked the question.
Yes, I appreciate that. But could I answer this in I think this is my fourth limb, as it were, of the answer. The fourth limb of the answer, and it is directly the answer to my learned friend, Mr. Jeremy, and to the Honorable Attorney General, which is that the GECOM is obliged to make a determination as to credibility. If I can read the paragraph 14, which is the operative part of the order, as amended on the 29th of May, it says, the Commission shall, after deliberating on the report at paragraph 12, that is the report that Mr. Lowenthal has produced, determine whether it should request the Chief Election Officer to use the data compiled in accordance with paragraph 12 as the basis for the submission of a report under Section 96 of the Representation of People Act, provided that the Commission shall no later than 3 days after receiving the report make the declaration of the results of the final credible count of the elections held on the 2nd of March. That is what they have done. They have considered the report under paragraph 12, and I should point out that under paragraph 12, Mr. Lowenthal is not required to make any determination as to the credibility of the election. He's not required to do that at all. He went outside of his crease, in other words, when he did that. He had no authority to do it. But what the commission did is to consider the report by him, and then they have directed that he use that report in order to prepare his report under Section 96 of the Representation of the People Act, so that they have made a decision. In other words, subject to what they have said about being unable to resolve issues of fact as to whether people were impersonating other persons and so on, and they were clearly correct in doing so. They have exercised their powers under the order, and they have directed Mr. Lowenfield to produce a report under Section 96. So they have done what they were supposed to do. In any event, Your Honor, they do not have, and I respectfully submit, they do not have the power to cancel an election. If you look at Section 163 of the Constitution, in particular 163, 163.4, it says Parliament may make provision with respect to, and if you look at B, the consequences of the determination of any question under this article, and the powers of the High Court in relation to determination of any such question, including, without prejudice to the generality, the foregoing power, provision empowering the High Court to order the holding of a fresh election throughout Guyana, or a fresh ballot in any part thereof, or the reallocation of seats in whole or in part. And that is in fact what Parliament has done. They have empowered the court to make such orders. So here you have a provision in the Constitution specifically giving the High Court exclusive jurisdiction to order a fresh election. And on what basis is it being said that GECOM can do exactly what the High Court is given exclusive jurisdiction to do? But let us try and say we rely on the Indian case, and why don't we want to look at that beautiful jurisprudence and so on that's coming out of India? But interestingly, in the Mohit case that my learned friends are relying on, that was the case in which the Commission had ordered election in certain districts, plural, to be held over again because there had been riots and so on. And the decision of the Commission to do so, because the vote was held again and there was a result of the election. The result of the election was challenged on an election petition. Sorry, on a constitutional motion, first of all. And the question that arose in the Mohit case was, do you challenge the decision made by GECOM to have a re-election in a constitutional motion? And the Indian Supreme Court says, no, you have to go by way of election petition to do that. And it is in the course of that judgment that the Indian Supreme Court then made certain pronouncements on the power of that commission to order a re-election, to cancel an election, order a re-election, however you want to describe it. It is in that context. But that case was decided in relation to specific provisions, which we have quoted in our submission, under their Representation of the People Act, which specifically gave the Commission the power to cancel an election. Actually, the wording of the Act was that you could only cancel an election in one polling station. And the question which arose is, well, can you do it in more than one polling station? That was really the question for interpretation in that case. So interestingly, that case is one that says you don't come by constitutional motion, you go by election petition to raise the question as to whether the Commission has the power to cancel an election. My little friends are not seeking to raise that question in an election petition. Worse yet, they're seeking to raise that question in an application under Article 177.4, where your jurisdiction is tightly circumscribed and clearly we respect, does not include the examination of a question as to invalidity, which depends upon an interpretation of an order that GECOM has made. So my learned friends are simply off the mark. They have come to the wrong place. They are invoking the jurisdiction of the wrong court at the wrong time, and without any procedural rules governing how this jurisdiction can be exercised. And we say that is a precondition to the exercise of the jurisdiction. And therefore, we respectfully submit that you ought to dismiss this application summarily. The complaints that have been made, nobody is suggesting that the applicant cannot make them. They can do so. there is an appropriate stage for the making of those complaints. That stage is the election petition. But they must allow the election to be completed. We now know that there has been a recount. We observed by outside observers who have pronounced upon the fairness of the election. We now know what the true recount is because everybody was there, and they now know it's no arithmetical problem anymore. We now know who got the most votes. If there are irregularities that put the validity of those votes into question, there is a place for determining that question. It is before the High Court on an election petition. It is not now. All my learned friends are seeking to do is to prevent the winning party from reaping the results of the election. All they are seeking to do is to prevent the electorate, which has clearly stated what their choice is, from having their government go into power. That is what they are seeking to do in the face of a recount showing what the valid votes are. All of these problems that have been raised can be addressed and resolved in the appropriate forum. This is not the appropriate forum. They're asking you to invalidate an election and you haven't heard any evidence yet about whether any of these irregularities have been established as a matter of fact. No evidence has been put before you, but they're asking you to consider the validity of the election of the president, which of course would not impact upon the validity of the election of the members of the National Assembly. That can go ahead. They can't seek to stop that because you don't have jurisdiction to deal with the members of the National Assembly at all. This is just causing further delay, Your Honor. Let it proceed, let it get to an end, and your learned friends can make their objections in due course, produce evidence before the court, let everybody have the opportunity to answer the evidence, have a proper hearing in which the principles of natural justice can be observed. In other words, let the election, the outcome of the election, be determined in accordance with fundamental principles of justice that we know. Evidence cross-examination. Evidence, importantly, not opinion, not supposition, not allegation, which is all we have at this point in time. And the chairman of the commission was quite right to say, we can't resolve these questions because that requires evidence. We cannot resolve it. We are not equipped to do that. To be honest, I think that I have used up the extra 15 minutes that my learned friend has seen. Unless there are any... No, I've used up the 15 that I've already been.
All right, so that's from you, Mr. Mendez?
Unless there's anything else that I can assist you.
You've been quite helpful. Thank you.
Much obliged, Your Honor.
Thank you. We move on. Mr. Rampuran, any submissions from you?
If it pleases Your Honor. If it pleases Your Honor, I'm not on video. I have been deprived.
Please go ahead. We're hearing you quite
Thank you very much. Thank you very much, Your Honor. Your Honor, I'd like to state that I rely on my submissions and on the submissions made by the chairman of the Elections Commission and by Mr. Jagdeo and Irfan Ali. Your Honor, most of what I intended to say have covered by the parties already. But I want to add that the issues which we are asking Your Honor to pronounce upon have engaged the attention of the Court of Appeal since 1968. Your Honor, the well-known case which emerges or which arises in every case that engages the court's attention has already dealt with the basis of the jurisdiction of the court under Article 163 of the Constitution. And it has dealt with every issue, every aspect of election petition and the laws surrounding election petition, and when we ought to go for election petition. I noticed Your Honor asked the question, asked the question about why we could have gone, or why the parties could have gone to court over the Mingo's violation of the law over that irregularity at one time, and we cannot go to the court on these irregularities at this time. Well, Your Honor, to supplement the answer given to you by Mr. Mendez, I should like to add that Mr. Mingo was in clear violation of the law to use the statement of polls in the tabulation of the vote before the count had finished, before the counting of the votes had finished, had concluded. Clear violation, and that was the time when the opportunity was taken to stop the violation dead in its tracks. In this case, the count has been concluded and officially declared by the Chief Election Officer to the Elections Commission. And the irregularities which have been alleged are of a nature which cannot be determined by the Elections Commission itself, which the applicants are asking Your Honor to do. So that is the reason why they need to go, as the Elections Commission has said, and as the chairman of the Elections Commission has stated in his submission, that you need to go to an election petition before a court which has the capacity to determine issues of fact. And Your Honor, there are a lot of issues. Mr. Lowenfield said that approximately 250 to 275,000 votes are not credible. So there are a lot of issues. Your Honor, from 1968 right up to the present, our courts have been inundated after every election with cases challenging the validity of all kinds of processes. Public law orders have been applied for, most if not all have been dismissed. Election petitions have been filed, and the only one filed was, the only one that went to trial was the case of Mr. Pereira, which lasted for about 18 months. And in that case, a constitutional provision was challenged. The vote, it was alleged that the vote, among other things, it was alleged that the voter ID law had violated the Constitution, and the judge so held. Interestingly enough, Your Honor, I should conclude on that by saying that there are a large number of pronouncements which will aid Your Honor in coming to the conclusion, which I submit that you should, that the matters complained of are matters which ought to engage the attention of the High Court on an election petition. Your Honor, the count I have presented to Your Honor the report of the CARICOM observer team to the election. And that is to demonstrate to Your Honor that there is another narrative. There's a narrative as explained by the Honorable Attorney General, a narrative of fraud and chicanery, a narrative of despicable, a narrative of extraordinary circumstances. Well, there is another narrative, and that narrative is set up in the conclusion of the CARICOM team. And they say at page 58 of the report, overall, while we acknowledge that there were some defects in the recount of the March 2nd, 2020 vote cast for the general and regional elections in Guyana, the team did not witness anything which would render the recount and by extension the casting of the ballot on March 2nd so grievously deficient procedurally or technically, or sufficiently deficient to have thwarted the will of the people, and consequently preventing the election resultant declaration by GECOM from reflecting the will of the voters. The actual count of the vote was indeed transparent. But Your Honor, what about that narrative? What does Mr. Williams say about that narrative? And what does Mr. Williams say about the narrative that the recount results officially acknowledged and placed before the commission, showing that one party has won the election by 15,000 votes, the PDP, over and above APNO-AFP, which Mr. Mingo's declaration had shown won? What about that narrative? And who is to determine the narrative of the CARICOM team, which is infused with legality under the Order 60 made by the Elections Commission? The order provides for the CARICOM scrutinizing team, and it provides for the team to give a report. So the report is an acknowledged document emerging from a legal process. And the fraud and chicanery mentioned by Mr. Williams, contained in the allegations made by Mr. Harmon, and in the report of Mr. Lowenfield, are dismissed by the CARICOM team and are yet to be proved. To be honest, I don't think the court would have any difficulty in finding that this matter ought to go where it belongs, and which have been decided 50 or more years ago, 50 and more years ago, in a case argued by Dr. Shahabuddin before then Chief Justice, I believe, Al-Ballas, decided 50 years ago and followed in every single matter by every single court since then. And I urge this court to follow the matter. Again,
Sorry.
Your Honor? Yes, Your Honor?
No, please go ahead. I wasn't sure if you were finished. I thought you were.
No, Your Honor. I haven't finished. Your Honor, 177.4 has been invoked already before this court in the matter of the UC Koyana's application in 1980. Your Honor, under section 10(1) of the Guyana Cooperative Something Act, it's contained in my submission, it provided that the then Prime Minister would be, would serve as a transition.
We have the benefit of the report, so
Yes.
we'd like to hear your submission on the principles. We have the
Yeah, yes, Your Honor. Yes, Your Honor. I'm not going to read passages and all of that from the case. I'm just going to give you a broad perspective of how I understand it and why it should influence the decision Your Honor to make. If you will permit me, Your Honor. Your Honor, the law provided, the section 10.1 provided that the then Prime Minister would assume a transitional presidency in October until elections are held in December. Because the Constitution, the 1980 Constitution had been promulgated, and the laws surrounding that provided for the transitional presidency. And he was required to take an oath. He added to that oath words to the effect, "So help me God." Koyana then brought an application to the Court of Appeal under 1774, challenging, seeking an order that the appointment of the president was null and void. And so it is. The same issues arise in this case. And I ask Your Honor to follow the decision in that case. The court held that there must be an election of a president. The Koyana was far closer, the Koyana case was far closer to the circumstances surrounding 1774. So this case we're dealing with now. The court said, election, there must be an election of the president. And the election must be a real election, not a transition from Prime Minister to President. So since there was no election, 1774 did not apply. The election in Guyana has not been completed. President Granger still occupies the office of the president. He's not left. Dr. Irfan Ali has not been sworn in. He's not yet the president of Guyana. So the election is not complete. So there must be an election. And secondly, the election must relate to qualifications. Your Honor, in my submissions, I've set out Section 90 at length, which provides for the qualifications of the president. And none of the issues raised in Section 90 have been challenged. In fact, what is challenged here are completely and totally alien to anything in relation to the qualifications of a president. It has to do with the results of the election. Your Honor, and it also has the second limb, the interpretation of the Constitution. Well, Your Honor, I set out in my submission, Dr. Shahabuddin, who also argued this case, Dr. Shahabuddin's understanding or his argument in relation to the meaning of interpretation of the Constitution. And obviously it does not mean interpretation of any section of the Constitution. It means interpretation in relation to the qualification of the president. And R.H. Lacour, Justice of Appeal, the late R.H. Lacour, accepted the submissions of Dr. Shahabuddin and therefore agreed with him on the limited interpretation of that section. So that this court, Your Honor's court, has already pronounced on the issue of the application of 1774. And if Your Honor takes that case on board, I think you will have no difficulty in arriving at the conclusion that Your Honors have no jurisdiction in this matter. Your Honor, I think it is not part of my submission, but I would seek to recommend, suggest, Your Honor, that we take serious cognizance and you view with great concern the blatant violation of his remit by the Chief Election Officer, whose powers under the recount order require him to make matrices of the statements of recount and to provide a summary of the observation report. Your Honor, the Chief Election Officer went beyond, unlawfully, beyond his remit and pronounced on the credibility of the election. Your Honor, I do not think that is a small matter. And it is that, having gone beyond his remit and having made those pronouncements, that is what is driving not only Mr. Harmon's complaint, but that is what is driving this unmeritorious case and driving these unmeritorious arguments and creating a situation which is delaying the results of the announcement of the elections in Guyana. Your Honor, those are very serious matters. And it ought not to be treated lightly by this court, because while there is no order, Your Honor would not have failed to notice that the Elections Commission is not proceeding with its business of making a declaration to the court. And it is in the public domain that the Chief Election Officer has not made a report to the Elections Commission as the chairman has required him to do, and he is required by law to do. So it is his violation of the law that is creating this difficult, unconstitutional situation in Guyana, which must be remedied. Your Honor, unless there is anything further you wish me to address you on, I would like to say I agree with the submissions on the rules issue, but no rules have been provided. Though that issue did not arise, I don't know how it missed Dr. Shahabudin, but it did not arise in the Koyana case. And I did not deal with it in my submission, but I just wish to offer my support to it.
The court has submissions on that point from
Yes, sir.
other parties in the case. So
Yes,
thank you,
sir.
Mr. Rampuran.
Thank you very much, Ibrahim.
We move on now to Mr. Khan.
Please support. Your Honors, I'm not sure if you're hearing me because I don't have video at the moment.
We are hearing you clearly. So please go ahead.
May it please the court. I wanted to begin by, as indicated in my correspondence, to adopt in its entirety the submissions of my learned friends, Mr. Mendez and Mr. Rampuran, as well as the submissions on behalf of the chairman of the Guyana Elections Commission. As indicated in my correspondence to the court, my submissions will be confined to an assertion that I made in paragraph 11.3 of the affidavit in answer, deposed by both Shazam Ali and by Mr. Kindi Ali, and that is that the Court of Appeal has no authority to grant restraining orders to prevent the first name respondent from performing his statutory duties as directed by the second name respondent in the context of these proceedings. But Your Honor, before I go to the meat of the matter, I wanted to address a question, if I may, that was put to my learned senior, Mr. Mendez, when you asked Mr. Mendez what was the status of the order. My response to that, Your Honor, is that the status of the order, that is order number 16 of 2020, in addition to the amendment, is the status of that order is that of a regulation. And this is why I say this. It is a regulation because it was made pursuant to a power, albeit a constitutional power given to it. It was not passed pursuant to an act of parliament, so therefore it cannot have the force of law. It is obviously not the Constitution. It falls in the third tier of the hierarchy of laws. It is regulation. The natural consequence of such an assertion, Your Honor, is this: that to the extent that those regulations are inconsistent with legislation, they have to be ignored. It naturally follows that if those regulations, worse yet, are inconsistent with the spirit, letter, and understanding of the Constitution itself, they also have to be similarly ignored. That, in short, compass would be my response to the question posed by the court. Secondly, Your Honor, I wanted to address an issue that was raised by Mr. Jeremy as it relates to the assertion that he made during his presentation that the chairman of the Elections Commission ascertained, I wanted to make sure that I get he said that the chairman of the Elections Commission invalidated the elections. I want to be very careful with this because I believe that the words of the chief elections officer, sorry, I said chairman, what I meant was the chief elections officer, he asserted, had invalidated the elections. I wanted to quote from the...
Excuse me. We take a contemporaneous note of what I said, and that comment...
Mr. Jeremy, prepare you have a few minutes to respond at the end. But let's hear what Mr. Khan is quoting you as saying.
Your Honor, I wanted to refer to the paragraph 26 of the affidavit in support of the motion. At paragraph 26, it says that in each of the reports of the said electoral districts, the chief elections officer stated, and I will not quote it in extenso, but the last part of it says, consequently, on the basis of the votes counted and the information furnished from the recount, it cannot be ascertained that the results meet the standard of fair and credible elections. There are two possible consequences of that. The chief elections officer is saying that he cannot ascertain the results. It does not necessarily mean that the results are not ascertainable, because it is not within his purview to ultimately determine whether or not the elections are fair and credible. The second consequences of him saying that is that he has, consistent with the report, summarized the irregularities, and therefore he has impliedly said to us that I have this information, I have these allegations, but given the fact that I have no investigative authority, it is not possible for me to ascertain. The word used there, ascertain, Your Honor, as I submit, is not one that is used lightly. He's saying, in effect, I have this information, I'm sending it to you, but I am not able to ascertain, based on this information, whether or not the standard has been met. He has not categorically said that the standard has not been met. He is simply saying, I can't ascertain. And therefore, it is open to the Commission, for reasons which I will show subsequent, to make that pronouncement. The third matter I wanted to address very briefly is this is in addition to the submissions made by Mr. Mendez in relation to the court's function, that is the Court of Appeal, in these proceedings. It is trite that the original jurisdiction in relation to petitions is one that is contained as part of the purview of the High Court. Nobody argues about that. But what is also equally important to note is that if the High Court has original jurisdiction and the Court of Appeal is a court of record, it therefore means that the natural consequence is that the Court of Appeal and its functions are inherently subscribed by what the High Court can do. It cannot be that the High Court and the Court of Appeal have the same broad range and depth of jurisdiction. The High Court is able to pronounce on these matters. If there lies an appeal, it then comes to the Court of Appeal as a court of record. I believe that is an important distinction to add to what Senior Mr. Mendez has already said. Finally, Your Honor, in terms of the matters that I wanted to canvass in response, we have the situation where we've been told that Article 163, and again, there is no dispute that these are matters concerning the validity of the elections. If therefore this Article 163 gives this broad scope to deal with all of these matters, 177.4, even 177.2, which is the one that speaks about interpretation, has to be naturally circumscribed by the broad powers given to the High Court by 163, which further buttresses the position that we ought not to be considering the matters which the applicant has canvassed in this court. These are matters essentially for the High Court. Now I move to the pith and substance of my submissions, Your Honors. And I do so with some trepidation, because I'm going to make an assumption. Let us assume that the court is persuaded by the arguments of the applicant and the arguments of the learned Attorney General, and finds its way to a position where it says, yes, we have jurisdiction. We are going to hear this matter, we have jurisdiction. We are able to not only have jurisdiction, we are able to interpret in accordance with what is being asked. Here now the court has to consider what is being asked of it by this applicant. And in that regard, I wanted to refer to paragraphs D, E, and F of the application that was made by the applicant. The applicant is asking in paragraph D, C, D, and E. At paragraph C, the applicant asks for an order restraining the Chief Elections Officer from complying with the directions of the chairman set out in the letter. Goes on, etc. But these are the words I'd like to focus on, if it pleases the court. Without the Guyana Elections Commission determining the final and credible count or the credibility of the general and regional elections. In paragraph D, the same words are repeated. They are again asking for an order restraining the Chief Elections Officer from complying with the directions of the chairman as set out in letter dated 16. And again, it follows, without the Guyana Elections Commission determining the final credible count as to the election. And the third order simply restrains the Chief Elections Officer from submitting a report containing votes that were not credible within the meaning of the order. For the reasons that I've already advanced, the order is regulation, so that whether or not the Chief Elections Officer most respectfully submits a report which seeks to say that some of the votes are not credible, the Commission still, by virtue of the representation of the People's Act, as well as the Constitution, has in its inherent power the authority to determine that. Now, I wanted to focus particularly on these words for this reason. What is being implied here in the orders that are being sought is that the Commission has not yet determined the final credible count or the credibility of the general elections. I would respectfully submit that that is not so, because the Commission, in the form of its chairman, having written to the Chief Elections Officer asking him to produce a report consistent with Section 96, has in fact impliedly determined that the elections results are credible. It cannot be that you're asking for an injunction, but that injunction is predicated on the commission determining something, when in fact, by writing the letter, they have already determined that. The only other implication it can be is that if you grant this order, you're saying to the commission that you must now go back and make a determination other than the one that the letter asking the results to be tabulated. That then takes us into the territory of going into the deliberations of the commission, which is straight law, no court can inquire into. That was one of the things that was canvassed by this very court, I believe, in Ulita Moore. So that in effect, what they are asking this court to grant is an order to restrain the chief elections officer in a way that allows the commission to go back and revisit what is the determination, quote, of a credible count and the credibility of the elections. That has already been determined. It is on the basis of that determination that the letter was sent to the chief elections officer. And it is not within the purview of this court, as in Ulita Moore, to go back now and tell the Elections Commission, you must go back now and deliberate once again and come up with somehow a different result. No court can do that, Your Honor. So for those reasons, I would submit that the orders being sought at C and D of this application ought not to be granted, cannot be granted, because it steps into the purview of the deliberations of the Elections Commission. The third order being sought is an order restraining the Chief Elections Officer from submitting an elections report under Article 177 2B of the Constitution, containing votes that are not credible within the meaning of Order 60 of 2020. That, again, impliedly resides in the Chief Elections Officer. You're saying that the report that he must submit must be a report containing votes which are not credible. Which then begs the question, how does the Chief Elections Officer determine what votes are credible and what are not? He clearly cannot do that. He clearly does not have the power to do that. And therefore, for those reasons, I would suggest that even if the court finds itself clothed with jurisdiction, even if the court finds itself clothed with the power somehow to interpret this application on its face, ought not to be granted. I must apologize because I had some challenges finding some authorities in relation to the public law element of injunctive relief. And I was only able to find that late last evening. And I want to advert the court's attention to Belize Alliance versus Department of the Environment, which is to be found at 2003-63 WIR. In that case, the Privy Council, it's at page, starts at page 57, Your Honor, paragraph 35. In that case, the court indicated that when the court is asked to grant an interim injunction in a public law case, it should approach the matter on the lines as indicated by the House of Lords in the famous case of American cyanamide, but with modifications appropriate to the public law element. The public law element is one of the possible special factors referred to by Diplock. Another special factor might be the grant or refusal of interim relief, which is likely to be, in practical terms, decisive of the whole case. But and it goes on to something specific to the particular matter at hand. In other words, Your Honor, the court, if it chooses to embark on that particular excursion, has to determine whether or not the grant or refusal of the relief that's being sought, which I think nobody doubts is injunctive in nature, is likely to be, in practical terms, decisive of the whole case. And I believe most respectfully, if one were to predicate the grant of injunctive relief in this matter, given what is before the court, in relation to the assertions, the bare assertions made in the affidavit, the court will definitely find itself doing so in a manner that is decisive of the case. And therefore, it is an excursion, most respectfully, I would submit, ought not to be engaged in. Further, in relation to this particular case, the court also referred to the very famous case of RV Secretary of State ex parte factum and the dicta of Lord Gough. This is to be found towards the end of paragraph 36, Your Honors. I don't propose to read the entire quote because it is fairly lengthy. But the salient part that I wish to refer to is that after speaking about the fact that there is no fetter on the court to grant injunctions in those circumstances in public law, it says that a party, this is at the top of page 58 as part of the quote, a party challenging the validity of a law must, to resist an application for an interim injunction against him or to obtain, which is what we're dealing with, to obtain an interim injunction restraining the enforcement of the law, show a strong prima facie case that the law is invalid. What in effect the applicant is trying to do in this case, Your Honor, is exactly that. They are trying to say that a combination of their interpretation of Order 60 of 2020, allied with the representation of the People's Act and even the Constitution, because they're here before the court under 177.4, which really does not give them any jurisdiction to do this. They are saying that all of these things are in effect show a prima facie case that the law is invalid. Because in order to make sense of an application of this sort under 177.4, you would have to, in effect, broaden the issue of qualification to such an extent and to such a degree that practically anything goes, which in effect takes away the general and comprehensive jurisdiction that is given to the court under Article 163. Your Honors, for those reasons, unless the court has any questions I have, and like I said, simply for the sake of completeness, when one peruses the affidavit in support of the motion, one would find that even if the court somehow finds itself closed with jurisdiction, this affidavit does not satisfy even the barest requirements for the grant of injunctive relief. It does not do the things which I believe every lawyer in this panel and indeed in the court would have had to have examined in order to satisfy the grant of injunctive relief. And therefore, my respectful submission with regard to this is that even if the court chooses to go in this direction, the court ought not to grant any such injunctive relief or declarations as prayed for. There is simply not enough evidence. There is simply not enough cogent arguments being made. There is simply not a legal basis or a jurisprudential basis for granting any sort of injunctive relief. As I indicated previously, my primary submission is that the court ab initio lacks jurisdiction in this matter. But I thought I would add this particular argument simply in the interest of completeness should the court find that it is somehow closed with jurisdiction. Unless there are any other questions which the court would have asked of me, those are my submissions, Your Honors.
Thank you, Mr. Khan. We have no questions. Okay. We've made notes of their submissions.
Most grateful.
Thank you, very helpful. Mr. Jeremy. Mr. Jeremy, we'll allow you now a short reply.
Sure. Your Honor, I would be filling in my duty to my client if I didn't. I had a number of interested parties. I joined 4 respondents, but I had a number of interested parties, and I must, with the court's leave, I will be as brief as possible, but I must speak to certain of the points made by...
If you can speak a little louder for us.
Okay. Your Honor?
Yes.
Your Honor?
Yes.
I'd like Your Honor, to allow me to address very briefly, or as briefly as I can, the numerous points which were raised in opposition to the applicant's motion. Now, I begin, unfortunately, Your Honor, by stating the obvious, which is that my client is Esyln David, so that I must draw a distinction between certain comments certain propositions which were made by the Attorney General, who I have named as a respondent, and the assertions which I made as the advocate attorney for my client. Now, I do not agree with certain of those propositions. The Attorney General stated that GECOM has made itself a court. I do not agree. GECOM is a statutory body. Its functions and powers are those set out, Your Honor, in the Constitution that I am asking this court to interpret. And that Constitution incorporates by reference acts of Parliament, including the act under which the impugned order was made. Now, that is all that I propose to say with respect to the Attorney General, but I take umbrage at the fact that my colleague and friend, Mr. Mendez, for one of the added respondents, lumped my submissions together with those of the Attorney General, who is a named respondent to these proceedings. It's a point that I must make. Your Honor, on the jurisdiction point, that point is addressed at length in our submission. But Mr. Mendez was allowed to develop on certain aspects of that point. And in particular, he was allowed to skirt around the fact that the Constitution uses the word may. Now, where the Constitution, the Supreme Law, vests a jurisdiction in a court in plain and unambiguous language, and states, as this Constitution does in subsection 5, that subject to the provisions of this Constitution, that's one subjection, Parliament may make.
Your Honor, if I may interrupt my little friend just a minute.
Mr. Mendez, I did not interrupt you, and perhaps you can speak at the end.
So, okay, if Mr. Mendez, if you really feel that you want to clarify, we can hear you for a minute or two when this journey is finished. But let's hear from you.
Thank you, Your Honor.
It's an objection, Your Honor. Not a clarification, it's an objection.
And what is it?
The objection is that the little friend is replying, and he has prefaced this part of his reply by saying that he's addressing an issue that I did not address. So by definition, he cannot reply, because he is replying to something I did not deal with at all. I can't see that how this could be the subject of a reply. That's my respectful submission. Come out of the court of
I hear what he's saying. I'm not hearing him out. So let's hear. I thought he was addressing us on the rules. Was that it, Mr. Jeremy? What are you telling us about?
Precisely that, my lady, and I have a contemporaneous note which I took when Mr. Mendez was speaking about the absence of rules.
All right. So we heard Mendez for a few minutes after. Okay. Yes.
So that at subsection 5 of the Constitution, 177.5, the Constitution, the supreme law of the land, subjects the provisions of the Constitution. It says subject to the provisions of the Constitution. Parliament may make provision for giving effect to the provisions of this title, and without prejudice to the generality thereof, may make provision. Now, the cases cited by my learned friend, and these cases cannot have been cited by him without them being cited by him. Gypsy and Chaitan, and the dicta of Mr. Justice Dilavas. Your Honor, as I said at the outset, that is a case where you had similar language. That is to say, the jurisdiction was given and the rules were not made. But rules were not a condition precedent to the exercise of the jurisdiction. That is the case of Gypsy versus Chaitan. And I mean, there's a long line of authority which I cite in my submission, including the Abu Bakr case, which is to similar effect. And when you square that, my lady, with the learning from the erudite court of Guyana in John Doe and the other cases that I have cited, I do not think that submission goes very far, with the greatest respect. Now, with respect to what I would call the more substantive argument, that is to say that the section is not triggered, the jurisdiction in the section is not triggered in this case. If not this case, Your Honor, when, with respect to the election of a president, there is no other provision in the Constitution which vests in the court, in the lower court, an express power, an explicit power such as this in the Court of Appeal or in any other court to determine the question of the validity of the election and the interpretation of the Constitution, insofar as the validity of the election of the president is concerned. Now, we are here dealing with the question of the validity of the election of a president. Whether that complaint arises today or tomorrow or yesterday, that is the question before this court. And that question, Your Honor, is a it resolves itself only by reference to the provisions of the Constitution. We are not asking this court to interpret the order as the second name respondent said. That's not what we are asking the court to determine. We are asking the court to determine the powers of the GECOM insofar as those powers are derived from the Constitution. And the powers of GECOM, as they are derived from the Constitution, directly relate to the Constitution itself, and by incorporation, existing laws, statutes. That's what we are asking the court to do. And this court has the sole power. It is not that it shares that power with anyone else. It has the sole power to determine that question as far as the president is concerned. This section is contained in the section of the Constitution which is titled the President. I rely on on my submission, which elaborate upon the absence of rules and the effect of the absence of rules on jurisdiction. When the absence of rules will deprive a tribunal of jurisdiction, very rarely, and I rely on the case that my learned friend relied on. That is to say, the Gypsy and Chaitan case, where at page 281, the then Chief Justice Dilawski says, I conclude that Parliament did not intend the failure of the Rules Committee to make rules specifically for election proceedings should prevent the court from exercising its jurisdiction to determine disputed elections, and that failure having occurred has not had that effect. So to conclude on that point, Your Honor, where the statute uses the words may, Parliament may make, Parliament does not act in vain. If it says may make, that is not to mean shall make. And the learned friend is pushing you towards, I think, an equation of the two which is not supported by the law. There is an exclusive jurisdiction conferred by section 177(4) to treat with the interpretation of the Constitution insofar as the president and the election of a president is concerned. Now, Your Honor, I hate to single out my little friend Mr. Mendez, but his submission attempts to push the application that my client has filed away from the plain interpretation of Article 177(2) and the meaning to be ascribed to the words more votes are cast. He raises numerous allegations of omissions on the part of the Chief Executive Officer. His grouse is one that is fit for Article 163. I am not asking the court to question any particular act or omission. I am asking the court under Article 177.4 to exercise its sole power in respect of the president to interpret the law with respect to the election of the president. That law is contained in Articles 177.2, construed, I say, in the light of Article 162 of the Constitution, which incorporates the Election Law, Amendment Act, the Representation of the People Act, and of course, the Election Law is what has given rise to this order that is made pursuant to the Election Law. Article 163, 1B, Roman I of the Constitution does not derogate from the Court of Appeals exclusive jurisdiction to interpret the Constitution. Nowhere in Article 163.1 does it confer jurisdiction to interpret the Constitution. Article 133 is a general provision that governs appeals emanating from the High Court. Article 177.4 deals directly and exclusively with questions on the validity of an election of a president or the interpretation of the Constitution as it relates to that. And I rest my case firmly in Article 177.4. Our case, Your Honor, is whether the CEO can determine the results using other than valid votes to put in a president. Do you put in a president other than what the Chief Elections Officer says are valid votes? And that relates to the interpretation to be put on Article 177, subsection 2 of the Constitution. Now, if Mr. Mendez is right, it means that there is no jurisdiction to have an election petition heard in respect of questions which speak to the election of a president. His submissions merge the jurisdiction of the High Court in respect of the National Assembly elections to the president. Now, at some point, yes, I'm coming to the end of a very long day, Your Honor. In Mohinder Gill, referred to by Mr. Mendez as an election petition speech. Clearly coming out of Mohinder Gill, which I think we can all accept is an important piece. Quite apart from the issue as to whether an election petition ought to have been a mechanism of challenge, the case is relevant to the question before this court in respect of what is a valid, free, and fair vote in the language of Article 324 of the Indian Constitution. That is what the court focused on. Now, there were references in the case, as pointed out by the second respondent. There were references in the case to the Act, and the Act is different in respect of impersonation and so on. But if you look at the case itself, the court says that the question that is posed is whether the Election Commission clothed with the comprehensive functions under Article 324 of the Constitution, which is Article 162 of the Guyanese Constitution, which cancels the whole poll of a constituency after it has been held, but before the formal declaration of the result has been made, and direct a fresh poll without reference, and it goes on to say, without reference to the guidelines that Molina's friend pointed out under Sections 58 and 64 of the Act, which is not present in there. So the court explicitly bases its decision on the Constitution. And it goes on to say at page 30, Your Honor, and these are important words, whether we make a triumph or travesty of democracy depends on the man as much as on the great national patriot. This is at page 30 of the case. No, listen. When a high functionary like the commissioner is vested with wide powers, the law expects him to act clearly and legally. Article 324 in Guyana, that is Article 162, is geared to the accomplishment of free and fair elections expeditiously. Your Honor, my submission is that when you read the Constitution as a whole, and the principles of statutory interpretation and constitutional interpretation require you to do so, where you see free and fair in 162, where you read what Mohinder Singh says about free and fair, we see that the question for this court to determine is whether or not the votes that more votes in the Constitution means, and this is a question of interpreting the Constitution, which this court alone can do, whether more votes means more valid votes, as it relates not to anybody else, to the president. And that, Your Honors, is a function which is entirely and only yours. If I could just quickly to the reliefs that we see. We do not, in anywhere in our reliefs, that I have to part ways with the fourth named respondent, the Attorney General here. We are not asking for an annulment of the election. We have reliefs A through H, and you will not see that anywhere. All of our declarations that we see and orders that we see are ancillary upon the exercise of this court's jurisdiction to interpret the Constitution to determine whether the question more votes means more valid votes. And if I can say it would be a sad day, that interpretation, which should which should commend itself to all of us, should in the case to declare someone president be ignored. Those are my submissions in reply to.
Yes, two very brief points, if I may. First of all, as far as the point that my learned friend emphasized in relation to the lack of procedure issue, and where he says that the section says that Parliament may make provisions. The fact of the matter is that in all of the provisions considered by all of the cases, Parliament or whichever rule-making body was given the discretion to make rules. In those cases in which it was held that the making of the rules was a condition precedent to the jurisdiction, the rule-making body also had a discretion. The distinguishing point between this case and John Doe and the other types of cases, and this is a point that my learned friend has not addressed at all, is that Article 173.75 says, in order to give effect to, Parliament may make provisions. Suggests that they don't have effect until those provisions are made. My learned friend has not addressed that point. I'm finished on.
I thought that you were objecting to having misquoted, but I don't think that it is quoted you, did you?
No, I was not objecting. I was not objecting to anything that is not replying. I'm finished on.
I thought that you were objecting to having misquoted, but I don't think that it is quoted you, did you?
No, I was not objecting. I was not objecting to anything that is not replying. Election is also invalidated. So my learned friend did not represent what I had said. Thirdly, my learned friend says that I represented the Mohandir Gill case as an election petition case. I represented it as a constitutional motion case in which the court said that the issue had to be dealt with by way of an election petition. And the last point that I'd address very briefly is that my learned friend right to think.
There might be an objection that you're being
Yes,
I'm addressing
unless we were going to allow you to clarify any misrepresentation and to check our notes to see what in fact we recorded. But
yes, please.
it would be fair for you to be allowed to argue further.
I'm not arguing.
All the other respondents may claim that right. So let's.
But there's one last.
Unless you're saying that Mr. Jeremy misrepresented something you said, then
So
I think you have been very full in your submissions, and you, I think, recorded and noted all that you did, or just noted what you said.
Lady, I appreciate that. My learned friend, Mr. Jeremy, just made summarized at the very end what his case was about, and this is the first time that he's presented it in that way. And that's what I wanted to respond to briefly. What he said was that what his case was about was simply to ask this court to interpret 177(2)(b) as requiring us reading more valid votes cast. Now, his previous submission was valid and credible. He's now saying valid. And the only point that I wish to make is that even if he was to persuade you to say that that is what the section means, then what? Then where do we go? If you were to say that, how does that affect the election in any way? It goes further.
Now, Mr. Jeremy, what was it?
No, I think he was objecting to me saying what I just did, milady, but I've finished.
So there is no end to this part of the hearing. I think we have heard all we needed to hear. We understand.
Your Honor, if I may be heard, Your Honor, because the Attorney General has been much in vogue. A lot of attention has been paid to him.
Anything you would also want to say?
Yes, please, Your Honor.
Or will we allow you 2 minutes, both of each of you, better time goes off. Mr. Mendez, I guess, set the stage for this to go on too long, maybe. But we would allow you 2 minutes each. But I think Mr. Williams was ahead. Over you first.
Yes, yes.
As it please, Your Honor, Mr. Khan said that the order cannot have the force of law. That is order number 60 of 2020. And I simply want to show Your Honor, quickly, Huffman and LaRoche, AG versus Secretary of State for Trade, 1974 to All England report. They said this: it must be borne in mind that an order made under statutory authority is as much the law of the land as an act of parliament, unless and until it has been found to be ultra-virus. So that quickly rebuts what my learned friend has said. In relation to Mr. Ramkaran and the CARICOM report, I just simply wish to say, Your Honor, that unfortunately in the order, unlike in relation to the CEO, no scope, no role after the receipt of the report by GECOM has been ascribed for that report. Nothing. It doesn't. The report, the order doesn't say what GECOM could do with it, but the order specifically says what the CEO's report is and what it must be. So we want to say that very quickly. I'm not going to go into the fact that Mr. Ramkaran quoted some item from that report. We all know that we are on record of saying that the report would be flawed because of the intervention of a principal who has an agent within the chief person committee. Quickly, I know Mr. Mendez said I'd try to put the party back in power and all of these things, but you don't want to be distracted.
We have the rest of your report, your submission.
Yes, please.
So,
And the question of pausing for the delay, Your Honor.
of what?
Pausing for the delay, Mr. Mendez was lamenting that this application before you, Your Honor, is causing for the delay, Your Honor. Of course, Mr. Mendez was in the holiday application when we were on the point of declaring a presidency. And they delayed it, and we're here till now. And we have submitted that the practice in our jurisdiction is that once we're in the period of elections, you do not interrupt the election until after the declaration is made.
All right, so that's not the issue at this
So we cannot be bereft of our rights to pursue our remedies. And we are far away from declaration. We are far away from Article 163. We are only at the 3rd stage. So we have a right to vindicate our efforts in these matters. So I wish to thank Your Honor for giving us a hearing. I must congratulate you, Your Honor, on how effectively and efficiently you have actually allowed us to conduct.
All right, thank you, Mr. Williams. So we hope to have a Skype for a few minutes. A Skype on behalf of the chairperson.
Grateful, Your Honor. Your Honor, we simply wish to clear up what is the difference between first set of allegations and how they were dealt. And these final set, the first set of allegations, am I being heard, Your Honor?
Yes, Ms. Steiger, we're hearing you.
Okay, grateful. The first set of allegations in the first Halidar matter, the Yulita Morris matter, and this matter. That's all we wish to clear up. Your Honor, in relation to Halidar's application, the Honorable Chief Justice made a distinction. A number of orders were applied for by Halidar, but the Honorable Chief Justice in a ruling specifically said that issues of credibility and the integrity of the election, and actually who had won because some SOPs were tendered and all of that. The court said in definitive terms she will not entertain that type of application before her. She will not grant those orders because those things are the remit for an election petition. The court then said she will only deal with a very narrow issue, very narrow. And this was whether or not Mr. Mingo had complied with Section 84(2) of the Representation of the People's Act. She said specifically the other issues as to the SOPs which were being attempted, and other orders which were sought, the court specifically refused to entertain the application. So the issues in respect of the credibility of the election, in relation to those first set of allegations, they were not dealt with by the Honorable Court. The court ruled specifically that that would be for an election petition, and she would only consider a very slim, narrow point. Your Honor, the issue again came up in the Yulita Morris matter before Justice Holder. Thus, in relation to, there was an application to tender the SOPs of the main opposition party, and Justice Holder refused that application on the same principle that those issues will really properly and be better ventilated before an election court. He also echoed the sentiments of the Honorable Chief Justice in Halidar, that issues of credibility, that those things are really for an election court. So, Your Honor, hitherto, this matter reaching the stage where it has reached, both courts in the High Court cleared up this issue, that they would only entertain very, very narrow and specific issues, so that the credibility was not dealt with. Courts reinforced the jurisprudence, which I respectfully believe is settled in this country, that the issues of credibility for an election really has to be dealt with by virtue of an election petition, where the evidence can be tested, and the court hearing that matter can determine what weight to put on that evidence. So I was just trying to clear up that part for this Honorable Court. Thank you very much for my 2 minutes.
I'm afraid I have to disagree with Ms. Kite that those cases never dealt with the issue of credibility. In fact, the court said that those matters. Yes, but just let the record show that Halidar no more dealt with issues of credibility.
Saying that Halidar did not deal with credibility.
Respectfully, I'm objecting to this banter with my learned friend. There's a discipline. The court allowed my learned friend the opportunity to have a rejoinder, which she did have, and now she's engaging in an ill-disciplined discussion. Lady, I respectfully ask that the court gives us a date for the judgment, and please do not allow my learned friend to extend the remit. Respectfully.
All right, the court has noted all the submissions. We thank both for how you've dealt with our queries, and we will consider the case and deliver our decision on Monday at 1:30. That's
Much obliged, Your Honor.
Monday, the 2nd of June at 1:30 p.m. For
Much obliged.
we are indeed obliged, Your Honors.
Done.